The first key element is that there is an impartial third-party facilitator. This person makes the entire process work. And as long as there is a neutral facilitator, then the parties can trust that they have some safety and are not being abused by an interested party. This is very important for both sides. They have to know that the mediator is neutral and supportive of both parties and not an involved party. Thus, the first thing that makes a process one of mediation is a third party who facilitates, aids the parties in a neutral fashion to find the party's own best interests. The second element is having a mediator who protects the integrity of the proceedings. Usually, this just means that the mediator protects the confidentiality of the proceedings. Thus, not only does the mediator not take sides against any party to the mediation, but the mediator doesn't usurp the party's rights to disclose or not disclose information. The mediator preserves the integrity of the proceedings in all ways. Generally, this means many things, such as there are no records kept by the mediator. When there is no record, it becomes much harder to breach confidentiality, or to try to use the mediator to prove or force a particular point not finalized in the parties' agreement. In fact, some groups require the parties to take all notes on provided paper, and then take and destroy even the notes after each session. Confidentiality also means that the facilitator is not subject to subpoena and thus cannot be made a witness. Without notes or the facilitator, the only method to breach confidentiality is the testimony of an interested party, who is usually bound by law and thus subject to being quashed, not to disclose more than is agreed. A third key element of successful mediation is that all participants exhibit good faith. Good faith includes not only entering into agreeing to work towards a resolution, it also includes not using the process for outside purposes. This means that lawyers, attorneys, and non-attorneys can't abuse the process. What makes the whole endeavour mediation is that the parties are in the process to seek solutions. They are not there for an ulterior reason, such as abusing the other party by such a process. Both behaviour and integrity are important in creating and preserving good faith. The fourth element is that all parties are present. Only those with full authority to act for the parties must attend, so that the parties can work towards resolution. If the decision-makers don't attend, the process becomes something other than mediation. All parties necessary to resolve the problems should therefore interact with the mediator. In a family dispute, for example, if someone always checks with his or her parents before doing something, the parents should attend the meeting. In a labour matter, if a company president always checks with the majority shareholder before he makes a decision, well then the majority shareholder should attend the mediation. It is simply key to remember that it is the parties who are being resolved as much as it is the problem that is being settled. Finally, successful mediation requires an appropriate site or venue. Generally, this just means a neutral site that is conducive to the process. It must mean a place where neutrality, confidentiality, and inclusiveness can be obtained. The place is sometimes as important as the persons, and it is sadly a part of the process that is often overlooked.